Hello students, I am Assistant Professor Yashant Bhora at the School of Law, and today we'll be talking about the Evidence Act. Our topic is Introduction of Evidence Act and its salient feature. So let's start the topic. So before starting the topic, I'll suggest students to please keep one bare act of Evidence Act with them so that it will be easier for them to understand this particular act. Otherwise, there will be a lot of problem in the understanding the provisions of the bare act. Okay. So as we all know, that Evidence Act is one of the major uh, act in the IP in the legal fraternity, and without this particular act, nothing can be possible. So first of all, we'll talk about the kinds of law. So you can see on the screen that there are two kinds of law basically. One is substantial law and one is adjunctive law. Now, substantial law it talks about right and duties and liability of the person, while adjunctive law defines the procedure of the court. It means that uh, whenever there is any dispute of right, whenever any dispute of liability, whenever in disputes of duty regarding the person, what will be the procedure? It will be mentioned in the procedure code or the procedure of the in the adjunctive law. Now, giving example of substantial law, you'll see there are so many criminal and civil laws such as IPC, contract law. All of them are the substantial law, and in adjunctive law you will see the procedural law and the evidence law. Procedural law as in CRPC, criminal procedure code, and CPC, civil procedure code, and evidence act. Therefore, i'll I'll tell you that the evidence law is an adjunctive law, and it shows the procedure of that uh, particular evidence. Okay, so let's move to the history of the evidence law. To understand history in a better way, what I had divided evidence history of evidence law into three major era. First is ancient era, the second is Mughal era, and third is British era. So now we'll be discussing about the ancient era. See, ancient era, you can see from the ancient time there are the traces of laws of evidence, and it can be found from the ancient Hindu period. If you have if you know about the Shastras, the Smritis, all of them are the some types of law, and they are governed by these particular Shastras and Smritis. I know you must have heard the about Manusmriti. Manusmriti is the first code of law in the Hindu in the ancient era. So that means evidence is not a new concept, but it is from it can be taken from the ancient time on the ancient era. Now moving further, you'll see that other sources of laws are such as they derive their authorities, or they derive their things from the Smritis and Vedas. Smritis such as Yajnavalkya Smriti, Vedas, we have four Vedas, and from that we can see that the laws of ancient Hindu law are derived their authorities from this particular thing. So therefore, it is like the law is not, again I'm saying that the law is not the new concept. Evidence is again not a new concept, it is a very old concept, and it has been followed since ages, or you can say since ancient period. So you'll see that according to Vashisht, you must have heard the name of Maharishi Vashisht. He uh, said that said that there are basically three kinds of evidences. First is Lekhya, second is Sakshi, third is Bhukti. Lekhya means documentary evidences, Sakshi means witnesses, and Bhukti means possession. So, according to ancient Hindu law, there are three types of evidences present in the evidence law. Okay, Lekhya, Sakshi, and Bhukti. Now, moving further, you will see the evidence law of evidence in the Muslim period. So, as we all know that Muslims are governed by the holy book Quran, and Quran sets all the principles, all the laws, whatever the Muslims follows. So now in Muslim law there are two types of evidences. One is oral evidence and other one is documentary evidence. So you'll see in the Muslim era they believed that there are two types of evidence. One is oral and one is documentary. Now moving further, you'll see the law of evidence in British era. Now, as we all know that Britishers came in the year 16th century and they came as traders, but on the later time they became the ruler in India. So after uh, sometimes they started thinking about the India and thinking in sense that if they will be able to get the law very rightly and correctly, then they will be able to rule very powerfully. So they started checking out the laws. As we all know that India is a very diverse country. There we have so much diversification in the population. There is Hindu, there are Muslims, there are Sikhs, there are Christians, there are Parsis, there are each and all, like each and every type of community you will find in India. So, and they also governed by their own personal laws. So to make the law understand more understandable for the Britishers to govern India, they started codifying the law. So, right now, talking about the Indian Evidence Act, you'll see that in the 1835, in the year 1835, first attempt was made to codify the law of evidence, and finally, in the year 1872, on 1st September 1872, the Evidence Act came into force. Okay, and you again see on the March, it was enacted. So now you'll come to know about like you got the knowledge about what is Evidence Act and history about the Evidence Act. Now we'll talk about the parts of Evidence Act. So this particular evidence scheme of the Evidence Act is like the Evidence Act is divided into three major parts. First part consists of chapters. First part consists of chapter one and chapter one, chapter two, okay, and consist of section from section 1 to section 55, and all these sections talks about the relevancy of the facts, that what facts are relevant in the court of law. Now the second chapter you will see consists from chapter 3 to chapter 3 to chapter 6, and it consists from section 56 to section 100, which deals with mode of proof, that what is the proof and what will be the mode of proof. Now chapter part 3 consists from chapter 7 to chapter 11, and it consists from section 101 to 167, and it deals with the production and effect to the evidence. So now you'll see that there are total there are three parts in the Evidence Act, and there are section 167 in the Evidence Act, and these three parts, part first consists of the relevancy of the fact, uh, second consists of the mode of the proof, and third consists of a third part deals with the production and effect to the evidence. So I hope right like now you have got the knowledge, or you have got the idea about the history of the Evidence Act, and again you have got the scheme of the Evidence Act. Okay, I'll rest my lecture here and see you in other lecture. Till then, take care and take care of yourself. Bye.